Good afternoon. Your Royal Highnesses, Your Excellencies, dear members of the audience. As you can see from the program, this panel will focus on trends in the global ADR industry. Not an easy task, as we merely have 45 minutes to do so. Obviously, we had to select a few issues we would be able to touch upon, and these range from more general issues to more specific ones, ranging, as you will see, from developments in the arbitration space in the MENA region, trends relating to energy disputes, specific issues relating to construction disputes, to procedural good faith, and last but certainly not least, the impact of sanctions on international arbitration. Mr. Nolz, allow me to turn to you first. I wonder whether you can summarize some of the developments in the arbitration space in the MENA region, and actually also where you see the benefits of the changes that you will refer to.
Thank you very much, and good afternoon, everybody. Delighted to be here. So I just wanted to say a few things about the changes, the flurry of changes, if you like, that there have been in the arbitral institutions in the region. And in due course, you'll see why I want to focus on some of those changes. I'm not going to give you a lot about the detail, but there's some changes that everyone will be reasonably familiar with. And broadly, there's two categories of changes. We've had changes in institutions replaced by other institutions, and we've had changes in rules. And perhaps with the SCCA, perhaps it's been a hybrid, but I'll come on to that in a second. So, of course, we've had the DIFC LCIA, which has now become DIAC. That was a little bit of an unexpected change and has not been without a certain amount of controversy. And many of you will be aware that there have now been a couple of awards that have not been enforced in the US as a result of some of those changes. So it has created a certain number of problems. And of course, in Abu Dhabi, we have had ADCAC, which has now been replaced by Arbitrate AD. And then we've had new rules. We've had rule changes, of course, DIAC, Dubai, Arbitrate AD in Abu Dhabi, Corsica in Cairo. Sorry, I always find that a terribly difficult acronym to pronounce, but I hope I've got it right. And perhaps more significantly, as I mentioned, with the SCCA, where we've had rule changes and a new court, which, if you like, has put the SCCA on a much more solid foundation, with a structure that will be familiar to users from around the world. Now, in relation to those changes, probably the most important thing is that we've now got a set of rules in the region that represent best international practice. They will be familiar to anybody involved in the arbitration space, and perhaps are even, in some cases, at the forefront of the development of rules in arbitration. And a good example of an interesting amendment that has come through has been in the SCCA rules. That's Articles 11 to 14, which focus on multiple contracts, joinder, consolidation and coordination. And they probably represent leading practice from around the world. But I do have some concerns, if that's where I'm supposed to be going next.
Yes.
And it's not so much around the detail of the changes, because the changes have, as I say, put the institutions on strong footing and have created up-to-date rules, which everyone is familiar with. But we have seen a lot of changes. The changes have been fast and in some cases not expected. And we arbitration practitioners and many of our clients are to some extent a bit of a conservative bunch. And our clients need to be able to see that when they put in place and agree a provision for dispute resolution with an arbitral institution in that provision, that when they come to have their disputes resolved, maybe a year, maybe 2 years, maybe 10 years later, they need to know that the arbitral institution will be in place, that the rules are broadly the same, or perhaps the old rules will apply, so that international investors in particular can become comfortable with the dispute resolution capabilities in the particular institution.
So now you referred to the potential clients, but do you have advice you want to share with those involved in running these centers?
So I think there's just 2 points, being very conscious of time. The first is, I've mentioned there's been a lot of change. That's great, everything is now up to standard. But I think I would caution against too much change, too fast, with not enough consultation. It's very important that commercial clients, that practitioners know what the dispute resolution mechanism looks like, how it will be effected in practice. The second point I have, which is perhaps something that you don't see in the rules, is perhaps not talked about so much, at least not so publicly, is about the administration services in the institutions. If you have an institution and the clients and the law firms cannot get a proper and a prompt response to their inquiries when they're trying to start a new arbitration, trying to get proceedings afoot, trying to deal with difficult issues, that will get around in the market. And there have been some problems with the efficiency of administration in institutions in the region. But I'm glad to say that I'm aware, having met many of the administrators here this week, that the SCCA has put a lot of effort into getting that administration right. And the second point, which I've already alluded to, which brings me to the end of the words I wanted to share, is we've had a lot of change. Please, it doesn't always have to be the newest or the best or the shiniest. It's really important that commercial clients, law firms can build confidence in the institutions, and that there can be a good body of work that's built up so that trust can be built and experience can be established.
Thank you very much. Now, Mr. Quinn, allow me to ask you 2 questions. One relating to investment arbitration and one relating to commercial arbitration in the energy sector. At last year's COP28, states did agree to move away from carbon sources of energy, and I'm quoting, in a just, orderly and equitable manner, unquote. Some states, as we know, have taken a more aggressive approach towards energy transition. Has this led to disputes? Has this already triggered these kind of disputes?
Yes, I think it definitely has. Some states have taken that commitment more to heart and more aggressively than others, perhaps especially in Europe. But in doing so, these states have found out that these policy goals have run up against commitments that they have made in treaties and elsewhere to provide fair and equitable treatment, among other protections, as well as under commercial agreements. So that this has had consequences. We've seen a number of arbitrations now where there's been a failure, alleged failure, to compensate properly for accelerated phase out of projects, as one example, or failures or denials of production concessions or permits where the claimant claims that such a commitment had been made. So these states that have been aggressive have faced some of these claims. For example, the Netherlands has had to face at least 2 of these claims. ExxonMobil, Holland, and Shell, Netherlands versus the Kingdom of Netherlands, a case that our firm happens to be involved in. Shell and Exxon had been operating the Groningen gas field in the Netherlands through a joint venture company. The gas production field is alleged to have caused some tremors. This led to the conclusion in 2018 of heads of agreement pursuant to the joint venture in the Dutch government, providing for the phasing out of gas production in the field by 2030. However, in October 2023, the Netherlands decided to stop production in the field, accelerating the phase out of the field. So claims have been brought under that heads of agreement. Similarly, relating to the same field, the Netherlands decided in 2019 to phase out the production of fossil fuel exploration in 2030. German energy companies, RWE and Uniper, brought claims against the Netherlands under the Energy Charter Treaty, claiming that the phase-out did not adequately compensate them for the alleged illegal expropriation of their investments. Now, that arbitration was withdrawn and came to a conclusion, but I think both of these treaty claims against the Netherlands highlight a potential trend here, as states are properly enthusiastic about embracing policy climate goals, particularly in the European states. These phase out of traditional energy sources and could potentially and have come into conflict with treaty obligations. Other cases, the Westmoreland Coal Company versus Canada, a U.S. company, Westmoreland, claimed it was unlawfully excluded from a scheme to compensate investors for losses associated with the Alberta government's climate leadership plan, which accelerated the deadline for the phase-out of coal power in 2030. There's also an arbitration brought by Vattenfall versus Germany, a similar pattern. We've seen kind of similar things in the renewable space, where there was a time when governments were so eager to promote renewables, solar and wind energy development, that they made these commitments and incentives. And now, as companies piled into renewables, there's been a tendency in some jurisdictions to withdraw those and end those. We saw that, for example, in Spain, where there are now no less than something like 50 arbitrations brought in the wake of the phase-out of the kind of open-ended solar incentives that were recognized in that country. So we think this is obviously a real potential conflict between the policy goals and the commitments that have been made to investors.
So are there any other types of disputes that may arise of what I mentioned earlier being an aggressive energy transition policy?
Yes, we've also seen claims relating to what was so-called denial of permit cases. Now, countries have no obligations to give permits, to give authorizations or licenses for companies to mine or to take actions to develop energy. But once they have made some assurances, once they have made some commitments, then they can be held to those. And we're seeing countries being held to those and claims that are being brought on these so-called denial of permit cases. One example is the Rockhopper case against your home country, Italy, where it's kind of the impairment, it's kind of the paradigm for one of these. There were environmental concerns. The Rockhopper had apparently explored and discovered an oil field off the coast of Italy, but was denied a permit to extract the oil after a referendum in Italy banned exploration and extraction of offshore liquids and hydrocarbons. I think we may see more cases like this, where a company has taken certain actions, made certain investments based on what they believe were assurances that they got, and then there's a change of mind, maybe a change in administration, maybe a referendum, and it doesn't, the situation changes and the company is not permitted to go forward.
So allow me to shift to commercial arbitration. Now, the COVID-19 and the war in Eastern Europe have caused great volatility regarding and relating to energy prices. And what disputes or what type of disputes has this led to?
Energy prices, and in particular gas prices, have been more volatile in generations, especially in Europe. Just for example, In May 2020, the price of 1 megawatt hour in Europe was just 3.5 euro. Energy prices soared following the invasion of Ukraine, and in August 22, 1 megawatt hour was selling for 300 euros in spot markets. Obviously, this causes chaos in the markets, and the result, the way this plays out, are gas reviews under long-term gas contracts. Companies are seeking to use contractual mechanisms in those long-term contracts in order to reprice the gas pricing under those deals. But similarly, though, we've also seen companies decide that it is more economical for them not to deliver gas or oil under existing contracts. They may have some language under the existing contract or some body of law, frustration of purpose, or similar concepts under civil law to say there's been such a change in circumstances that we can't be expected to. We simply cannot. It's not commercially reasonable for us to expect to deliver at the stated price in the contract. Of course, there you run a risk of a claim of anticipatory repudiation. So we're seeing those claims being brought as well.
But so the prices of commodities, so not just fossil fuel prices, have been volatile. Has this led to other types of disputes as well?
Certainly. I mean, in the renewable space, just for example, the wind turbines require all kinds of minerals and commodities like copper and zinc. And the prices of those commodities have spiked as well after the pandemic. This scrambled some of the price assumptions under which those transactions, deals, and contracts were based. So some of these contracts have so-called price review light clauses that don't actually have a mechanism, contractual or arbitral mechanism for setting a new price, but they may require the parties to negotiate. And we're seeing those types of claims as well relating to other types of commodities.
Thank you very much. So allow me to go further. Mr. Moreira, you are focusing, as we know, on construction disputes, where it appears that there is a growing tendency to first resort to means of resolving certain disputes by ways or other than full-fledged arbitrations, specifically through involvement of adjudication boards. Can you maybe talk about that? And then I have a few more specific questions.
Thank you. Thank you, Professor. Yes, this is true and curious at the same time, because despite the fact that in Brazil, the so-called dispute adjudication boards, or DBs, they don't have jurisdictional power over the parties. Their decisions are only contractually binding on the parties. We've been seeing the past 5 years a consistent growth in their use. I'll try to very quickly summarize the reasons, in my view, the reasons for that growth. Brazil is experiencing lots of complex projects, not only in renewables, logistics, infrastructure in general, but also because of these natural resources. We are becoming a central player in energy transition projects like hydrogen, biofuels. So the market's becoming more sophisticated, and the legal market has to follow that. And one of the reasons, in my view, that we are seeing this growth is because many of those projects, or mega projects, as we may say, they are being financed through project finance. And when lenders take construction risk, they usually analyze the project agreements very carefully. And when it comes to construction agreements, they usually require the use of DBs in the contracts they are financing. So institutional, multilateral institutions such as the IDB, the Inter-American Development Bank, the World Bank, the Brazilian National Development Bank, BNDES, are good examples of institutions that require the use of DBs into the contracts they are financing. And although they often don't really check if they are being well implemented, but it's a different discussion, but at least it's definitely a trend. The other reason is, in my view, that some pieces of legislation are coming to play recently on public procurement, enabling or fostering the use of DBs. For instance, the state of São Paulo, which is the most important state in Brazil for business purposes, recently enacted a piece of legislation recommending the use of DBs in their public auctions. The new federal procurement law, it allows the use of DBs in public procurement, and we are expecting to see this year a piece of federal legislation regulating the use of DBs in concession agreements. So in countries like Brazil, where the state is a main driver for investment in infrastructure, of course, when they start to use or to discuss the use of such an instrument, other stakeholders like in the private sector, they do the same, or they have to follow that in some way. And the third reason is of more an educational, I would say, standpoint. Finally, in my view, owners and contractors are starting to realize that the use of DBs in their contracts can be beneficial not only for the project, but for their own sake, individually saying. It's not unusual that an owner finds itself hostage of a situation where it has good grounds, a good case to go to arbitration, but because of the construction phase or because of the type of the project, to replace the contractor is almost impossible. So it's ended up having to pay or advance payments to have the project be concluded on time. On the other hand, contractors in projects that they can be easily replaced or where they are part of a consortium, for instance, they have to sustain the work, sometimes even finance part of the works, having change orders or the claims being delayed on purpose by owners that they ultimately don't need them. So yes, it's interesting, but in my view, it's a trend, and it's a consistent trend, in my view.
Thank you very much. You have referred also to whether, at least in your country, DAB decisions are actually enforceable or not. Does this fact, does the perception relating to that enforceability or not have an impact on the client's desire or imposition to put it into the contract?
Yes, the answer is yes. In Brazil, as I mentioned before, the DAB's decisions are only contractually binding. However, in my view, this will not refrain the trend of growth. And for the reasons I mentioned, at the end of the day, it's interesting because even in theory, the DABs, they don't have a jurisdictional power. In practice, experience shows and data shows, for instance, the DRBF Dispute Board Foundation has interesting data to saying that more than 90% of DAB's decisions, they don't go to arbitration. And even when they do go, only a minor percentage of them are overruled by arbitrators. At the end of the day, the DAB is as good as the members you chose, so their decisions are unlikely to be overruled by an arbitral tribunal. And when stakeholders start to understand that and to experience that, even though without the jurisdictional power, in my view, they will start seeing that more and more.
So the trend will continue?
I believe so. And it's an opportunity for foreign arbitrators, foreign experts to participate in this trend. We are already seeing a lot of foreign arbitrators acting in Brazil, a lot of external experts acting in Brazil, and for foreign investors as well, seeking a very sophisticated legal environment. In my view, it's a trend to stay.
And do you see a difference between Brazilian arbitrators having to deal with the DAB decision and foreign arbitrators having to deal with the same decision?
No, I don't think so. I think lots of those projects have a very important international component. So we are getting very used to see international arbitrators, international experts dealing with that. Of course, that when you have a project in Brazil, we highly recommend to have the venue in Brazil, because our international arbitration award, to be recognized in Brazil, they have to go through the High Court of Justice, and it can take some time. But the sophistication of the decision, of the discussions, I don't see any difference. And mainly because many of them are held in English. So.
Thank you very much. As I said before, we wanted to first deal with some more general issues and then go into specifics. Mr. T, I turn to you and to the issue of procedural good faith. For those unfamiliar with what you consider to be this procedural good faith, could you please elaborate on what you think it is?
Thank you, Franco. It's my privilege to be here, and I thank the organizers for inviting me. I want to start off by talking in very basic terms about what it actually means when two parties sign an arbitration agreement. And I would say that it's very different to going to court, or indeed signing a contract to agree to go to a certain court. And the big difference is that whether or not you have an agreement, the court will have authority. When you go to arbitration, or when you sign an agreement to go to arbitration, you are conferring on that one person, those 3 persons, or those 5 persons, as the case may be, authority. You're giving them legitimacy. You're giving the entire process legitimacy. But for the agreement, these 3 people have no power over the parties. Because of that difference, and building on that basic concept, comes the theory of procedural good faith, that because the parties confer powers on others to hear and determine their disputes, they necessarily also promise to each other and to the tribunal to operate the entire process in good faith. They must support the process rather than to subvert it. And that support for the process is more than just cooperating during the process, but also a duty to honor the outcome, the result of that process. And that's what I mean when I speak about procedural good faith, which I think is a very, very important, it's very basic, but it's very important global trend. In our work, spanning many cities from Seoul to Hawaii, we see different forms of arbitration. We see how arbitrations succeed and fail. And if I can distill it, it's of course very difficult to distill it into one single thing, but very often the inefficient arbitrations, the unsuccessful arbitrations, is where parties don't exhibit and don't perform procedural good faith.
Now, having listened to the previous speakers who talked about developments in MENA region arbitration, trends in energy arbitration, and of course also the fight against the complexification of construction disputes, how can procedural good faith be used and better that area?
Yes, I listened with great interest to what John and Tieago had to say about energy disputes and construction disputes. Those are some of the areas in which I would suggest, of course they're not the only areas, but some of the areas in which procedural good faith is very important. I would suggest to SECA and to other arbitral institutions in the region that there are 2 paths to take. You can encourage and operate procedural good faith to its limits and try and make the process as efficient as possible, something that the parties find satisfactory, if not a very fulfilling experience. Or you can choose the other path and basically operate arbitration as litigation dressed up as arbitration. I believe that arbitration is different from litigation. If the parties wanted to litigate, they wouldn't enter into an arbitration agreement. So it must mean something to say, I agree to arbitrate my disputes with you. And that's something I would suggest is to support, or perhaps not to support, but to collaborate with each other to achieve a meaningful, substantive result. We're not here to achieve a resolution by a technical result and to win because of a certain rule that is to our advantage or because of a certain rule that's broken. What the parties want is to feel that their disputes have been resolved so that they can go back to the business of business. They're not in the business to litigate or arbitrate.
I wonder, of course, there is always a thought that at one point there may be post-award litigation. So what effect may the procedural good faith during the arbitration have on the post-award stage? I mean, as an arbitrator, you will always have to think about that.
Yes, yes, indeed. Well, it depends on the arbitral institute and whether they have a cost-shifting regime. If they do, then that is part of the procedural good faith. The promise to each party is that I will reimburse you for the expense you have taken to bring a just or a meritorious case to arbitration. But equally, depending on the arbitral institute's view, depending on the parties' views, depending on how the community wants to operate the resolution process, there could be a regime where the arbitration does not involve any cost shifting, as is the case in certain jurisdictions.
Thank you very much. Ms. Al-Rashid, you will be focusing on something dear to all of us, which has come to the forefront in the last years, meaning international sanctions. I wonder whether you can give a few general remarks, and then I have a few questions for you as well.
Thank you, Franco. Yes, so glad you said international sanctions, and that means we're talking generally, most probably, financial sanctions. Now, in starting on this topic, it's really important to remind ourselves that sanction regimes, whether by country or, excuse me, a designated person, can be implemented multilaterally by such as international organizations, European Union being one example, or autonomously by sovereign states under domestic legislation. And these two distinctions tend to have certain features in common, but it's also important to remember the differences, which make it imperative to check the underlying and more than likely not several rules that will come into play and during the arbitral process, during an international arbitration, and that will have significant impact on the international arbitration. And it's just important to highlight that the last probably 3 years, and the years are coming before us, we will see this develop over time. Generally speaking, and I know you'll come on to specific questions, Franco, but generally speaking, we're going to see more of an interplay between the procedural, substantive, and enforceability mechanisms of arbitration and how they interact with international sanctions, deeper and deeper into those particular 3 issues, which I can touch upon, of course, in greater detail.
So what are the practical issues and experiences arising from the imposition of these economic international sanctions, before we get to the uncertainties which you just hinted at?
The uncertainties are pretty much everything, to actually be frank. But the real practical implications on international arbitration vis-a-vis sanctions, financial sanctions, is obviously you're thinking about the parties to the dispute, right? And you hope you're dealing with 2 parties rather than several. You're thinking about the arbitral tribunal, who all come from different parts of the world. And you're thinking about the lawyers as well, who also, in our space, come from different parts of the world. So different sanctions regimes will apply, potentially. So keeping that in mind, this means that arbitrability of the dispute is one of the practical implications. The impact on jurisdiction of the tribunal and substantive merits of the dispute will come into question and will be impacted by sanctions, potentially, and may impact the actual issues of protection under, if you're dealing with investment treaty, protections under the investment treaty, but you could deal, that it'll be all the same with commercial arbitration when contracts are at play. And as I said earlier, just touched upon, the other practical implication is the conduct of the arbitration. Very, very relevant to issues of sanctions, because that's where you see the interplay of whether a party is sanctioned, and let's say it's a sovereign state, and it's sanctioned, and the procedures of an arbitration are that such party needs to pay the arbitral fees. Will it do so? Can it do so? Can a tribunal, or rather even an arbitral institution, depending on where it's located, accept such fees if such party is sanctioned, and that tribunal, where it sits legally, where it is venued for the hearing, and as well where the arbitral institution is located, I guess you could say incorporated or organized, depending on the legal stature of it, can they accept the fees, and can they allow, and can they actually implicate an award, which goes separately into enforcement, against the party that is sanctioned in favor of another party, especially if that particular state, where either the case is venued and or seated, is one of the parties or countries that is part of the multilateral mechanism that has a sanction upon that one of the arbitral parties. See, the complexities are pretty significant.
Let's add a level, because of course even arbitrators may be impacted by these sanctions. If you are a US citizen or even a green card holder in the US, you have to ask for certain OFAC licenses in order to be able to sit as an arbitrator. Now, let's get to the uncertainties which you hinted at, because it is true, and normally it happens, that more than one specific sanction regime applies in one and the same arbitration. So what should one turn to? The lex arbitriis sanctions regime? Should one apply a different one? You referred yourself to the law applicable to the merits, or even that of a third state. These are the uncertainties, are they not?
They are the uncertainties, and I have no definitive answer to the question, because they are uncertainties, and it is a developing field. The lex arbitrii will most certainly come into play. Without a question, that is most certainly the seat of the arbitration reflects upon the procedures of the arbitration and their procedural rules. And so that will indeed reflect upon the conduct of the arbitration, the procedural rules of that. And again, it rolls right into fees and the tribunal fees, the parties being, let's say, their interim measures imposed or asked to be imposed. That's another question. Are they financial? Are they with equity? All these are uncertainties that there really truly is no definitive answer, because we are still developing into the space. But I think one of the most interesting uncertainties and developments, because I can't give you an answer about all the uncertainties,
Yeah.
there are more questions than there are answers, and we don't know if it is the governing law of the arbitration that should apply to the question of whether sanctions impact. We don't know if it's lex arbitrii that should apply. We don't know if it should be the seat of where, because you have to consider, of course, the place of enforcement. So are those rules going to play a part earlier in the arbitration? Outstanding questions, uncertainties, and time will tell. But I really would like to bring to the attention of everyone here who's not rushing for the door for lunch, as I stand in the way for everyone's lunch. What's interesting is whether sanctions will become one of the issues to dispute in an arbitration, i.e., and I rushed to sort of investment arbitration because it's an easier, I guess, space on this subject matter of sanctions, international sanctions. Can a foreign investor bring an international dispute against a sovereign state that has sanctions against it which have now imposed upon the foreign investor's performance in the sovereign state? Is that by itself, could it be, for instance, resulting in an expropriation for which a bilateral investment treaty or multilateral investment treaty would allow a foreign investor to bring a dispute against a sovereign for the sanctions that are imposed upon it or that have impacted that party. That's one of the questions, and it is an uncertainty because it will, as this develops over time, it will become something we'll definitely see unclear answers to, but it will arise more and more.
And I've seen it in the commercial setting as well, so just to add. Thank you very much. I thank you. We have to cut this short in order to be compliant with time requirements. Thank you to everybody. Thank you to the audience for its attention.